So, good evening everyone. Welcome to Bajirao IAS Academy's daily newspaper analysis. Today is 25th November 2025 and today we have different topics for the discussion. The first topic is the advisory jurisdiction of the Supreme Court or Supreme Court's opinion on the presidential reference with respect to giving assent to the bills by the governors on those bills which are being passed by the state legislative assemblies. And the next important topic is the problem of malnutrition in India and how it is going to affect women, children, adolescent, girls as well. So we'll going to deal with this issue in a much more detailed and in-depth manner. And we'll also understand Justice Suryakant is taken oath as a 53rd Chief Justice of India. We'll also understand about this. And then Goa tiger habitat claims and the issues of these tiger habitats we'll also understand as well. So the first very important topic that we're going to start this session is about Supreme Court's advisory opinion. And in fact, a detailed article has been given in the Hindu newspaper, and from the syllabus point of view, this is very important for your gender studies paper too. So let's discuss about this recent judgment or the opinion of the Supreme Court, advisory opinion of the Supreme Court to the presidential reference that has been sought, right? So let's understand what exactly is this advisory opinion. Now, in fact, 16th presidential reference. So this has been given, sought by the President of India to the Supreme Court. Right, so this presidential reference is on whether judiciary can set timelines for the governor and the president when it comes to giving assent to the bills. Right, so this is actually what the presidential reference sought or dealt with. Right, so in fact, the presidential reference was sought under Article 143 of the Indian Constitution. Right. So, however, responding to this presidential reference, the Supreme Court held that, judiciary cannot set timelines for the governor and presidents when it comes to giving assent to the bills because it's solely an executive function. Right. So, it's solely an executive function of governor and the president. So, therefore, judiciary should not intervene in these matters, because giving assent to the bills is purely an executive function. So this is what the Supreme Court has said in this advisory opinion. Right? So let's understand what the Supreme Court has held in this advisory opinion in response to this 16th presidential reference. Now, Supreme Court held that governors cannot sit over bills beyond powers granted to them under Article 200. Now, what this Article 200 of the Indian Constitution says? Now, Article 200 says that whenever a state legislative assembly passes a bill, then the bill will be sent to the governor. So, bill will be sent to the governor for his or her assent. Right. So, however, Article 200 provides some options to the governor. So, what the governor should do with respect to the bills passed by the state legislative assembly. Now, if you look at those options, governor may give his assent to the bills. So, this could be the first option. And second option, governor may withhold his assent to the bills. Now, the third option, governor may send the bill back to state legislative assembly for reconsideration. And apart from that, governor may also reserve the bill for the consideration of the president. So these are the options which are actually available to the governor under Article 200 of the Indian Constitution. So however, the problem is that Article 200 is silent on timeline within which governor must give assent to the bills. So that's where the problem arises. Why? Because in states like Kerala, Tamil Nadu, Telangana, previously West Bengal, so what has been happening is that the governors are not giving assent to the bills. Now, if governors are not giving assent to the bills passed by the state legislative assemblies, what will happen? These bills may not become acts. So that is the problem, and that's why the Tamil Nadu government has approached the Supreme Court against governor, that governor is not giving assent to the bills passed by the state legislative assembly. Now, in response to this, Tamil Nadu, Tamil Nadu has actually approached the Supreme Court. Now, in this context, the Supreme Court has held that governors cannot sit on bills for an indefinite period of time, and Supreme Court has also set specific timelines for the governors for giving assent to the bills. For example, with the concurrence of the Council of Ministers on any bill, the governor must give his assent within 1 month. Right? So a governor cannot sit on a bill for an indefinite period of time. So without the concurrence of the Council of Ministers, the governor must express his views on this bill within 3 months. So this is what the Supreme Court has said. So that effectively means, so judiciary intervened in the executive functions, and judiciary also set timelines for the executive to give assent to the bills. And that's where under Article 143 of the Indian Constitution, so President Draupadi Murmu sought the presidential reference to the Supreme Court, asking opinion that whether really the judiciary can set timelines, whether judiciary can actually set timelines for the executive, right? Because otherwise it amounts to what? It amounts to the violation of a doctrine called separation of powers, right? So what is the separation of powers? There are 3 different organs, branches of the government: executive, legislature, and the judiciary. Now, separation of powers doctrine emphasizes that one branch of the government should not interfere in the constitutional functions of another branch of the government, which is the doctrine of separation of powers. And also understand, the doctrine of separation of powers is also part of the basic structure doctrine. Right, so this is also part of the basic structure doctrine. So if judiciary has intervened in this matter and judiciary has fixed timelines for the governor and president for giving assent to the bills, so it amounts to the violation of separation of powers, and again it amounts to the violation of basic structure doctrine. So this is what the Supreme Court has mentioned. And at the same time, the Supreme Court in the very same presidential reference has also held that governors cannot sit on bills for an indefinite period of time without any reason or rationale. Now, what without giving any proper rationale? The governor cannot sit on any bill for an indefinite period of time, for a prolonged period of time. So if governor delays giving assent to the bill without any reasons, then it may attract the judicial intervention as well. So this is what the Supreme Court has made with respect to the 16th presidential reference. So I hope it is clear for you, and this is what the Supreme Court has held that, right? So now, as I've already explained the background of the presidential reference, right? So Tamil Nadu state government has approached the Supreme Court, and Supreme Court has fixed timelines. So Supreme Court has mandated how many months? So 3 months of timeline for both governors and presidents for giving assent to the bills, right? So in fact, so such decisions will be judicially reviewable as well. So Supreme Court held that those decisions will also be covered under the judicial review of Article 32, Article 226, and even Article 13 of the Indian Constitution, because they talk about the judicial review power of the Supreme Court. And in fact, Article 142, so it talks about the power of judiciary to do complete justice in any matter, and as per Article 142, the powers to grant deemed assent to several pending Tamil Nadu bills, right? So in this case, there are several bills which are pending with the governor in the state of Tamil Nadu, and Supreme Court has used Article 142 to give assent to the bills, which is known as a deemed assent, even though there is no assent from the governor, but a deemed assent has been given by the Supreme Court under Article 142 of the Indian Constitution, which means the power of the Supreme Court to do complete justice in any matter. right? So however, this ruling has generated the constitutional uncertainty. What constitutional uncertainty? Because giving assent to the bills is an executive function. Here judiciary has intervened into the executive function. So therefore the questions arises were whether courts can prescribe timelines for the executive. So this is the first question that has arose. And then whether presidential inaction is justiciable, whether it can be covered under the judicial review, and Supreme Court's Article 142 powers can override the constitutional provision. So these are the main questions which came into the limelight, right? So a number of questions were asked in the presidential reference, right? So it has actually asked 14 constitutional questions before a constitution bench, and they primarily related to the interpretation of Article 200 and Article 201 regarding the state bills. As I've already told you that Article 200 of the Indian Constitution, it deals with a set of options that the governor will have with respect to bills passed by the state legislative assembly, and then those bills are sent to the governor for his or her assent. So this is the first question. So that has been referred to the Supreme Court by the president. And apart from that, whether courts can intervene before bill becomes a law. Now in fact, courts can intervene once a bill become a law under judicial review to check the constitutional validity of any such bill. But here the courts have been intervening before the bill becomes a law, right? So therefore, whether courts can really intervene before a bill becomes a law, and the justiciability of such delays. And what are the boundaries of Article 142? Can Supreme Court do everything under Article 142? Right, so these are the key questions which are asked to the Supreme Court through the presidential reference. I hope it is clear for you. Now let's understand what are the key takeaways from the Supreme Court's advisory opinion, right? So a 5-judge constitution bench of the Supreme Court has delivered a comprehensive opinion on the questions which are asked by the president as part of the presidential reference to the Supreme Court under Article 143 of the Indian Constitution. So let's understand what opinion that Supreme Court has given. So governor options under Article 200. So first thing that you should understand, as I've already mentioned, that whenever any bill is passed and sent to the governor for his or her assent, the governor will have the following options. He may give assent to the bill, he may reserve the bill for the presidential consideration, he may withhold the bill, and he may return the bill to the state legislative assembly for the consideration, for reconsideration as well. However, all these options are specifically mentioned, explicitly mentioned in the Constitution itself under Article 200 of the Indian Constitution. Now, in fact, the Supreme Court has also noted the discretion of the governor when it comes to giving assent to the bills, right? So, in fact, governor enjoys a discretion choosing among these options, right? So, Article 200 has provided governor certain options. So therefore, governor enjoys a discretion when it comes to which option that he may choose, right? So, and he is not bound by the aid and advice of the Council of Ministers regarding assent related decisions. This is what the Supreme Court has said in this advisory opinion. However, this interpretation of the Constitution bench of the Supreme Court is a significant shift from the earlier such decisions in Shamsher Singh 1974 and Nabam Rabia 2006 judgments of the Supreme Court, because so they have emphasized on the ministerial advice. The governor must act on the aid and advice of the Council of Ministers. But in this presidential reference advisory opinion by the Supreme Court, the Supreme Court clearly mentioned that he may, he is not bound by the aid and advice of the Council of Ministers when it comes to giving assent to the bills. He may enjoy discretion under Article 200 of the Indian Constitution, and he may choose any of the options which are provided by the Constitution under Article 200. And apart from that, the Supreme Court has also held that there is a limited justiciability. Now, in this case, before a bill becomes an act, Supreme Court has intervened. So therefore, Article 200 of the Indian Constitution, which generally provides certain options to the governor when it comes to giving assent to the bills, are generally non-justiciable in nature, first thing. Second thing, so in cases of glaring or prolonged or unexplained inaction on the part of the governor, so that means governor is not taking any specific action on the bills. So governor are simply delaying giving assent to the bills without any reason or rationale. Now at that point of time, courts may issue a writ called mandamus. Right, so what is mandamus? So mandamus actually means to perform your duties, to perform your constitutional functions. Right, so such a writ mandamus can be issued to the governor to act upon the bills which are pending with him or her. So however, the Supreme Court categorically mentioned that courts cannot review the validity of governor and president's decisions before a bill becomes a law. However, it is another matter that once a bill become a law, so the constitutional validity of such bills can be checked by the judiciary under its power of judicial review. But before a bill becomes a law, courts cannot intervene in this matter, because otherwise it leads to the violation of the doctrine of separation of powers. And next, no judicial timelines as well. Now, in earlier, Supreme Court has held that there should be a specific timeline within which governor and president must give their assent to the bills pending with them. But in this advisory opinion, the Supreme Court has clearly mentioned that there will be no specific judicial timelines. If judiciary set any timelines, again it leads to the interference in the functioning of the or constitutional functions of the executives. Now, no deemed consent. Now in this case, earlier Supreme Court has used Article 142, which talks about the power of judiciary to do complete justice, power of judiciary to do complete justice in any matter. So however, court strongly rejected the concept of deemed assent. There is no concept of deemed assent, holding that judiciary cannot substitute executive authority, although through Article 142. Even if we have Article 142, so there is no concept of deemed assent. President or governor must give giving assent to the bills. It is their constitutional duty, it is their function. Judiciary cannot intervene, cannot come up with a doctrine like a deemed assent, right? So in fact, the assent related decisions being exclusively to the governor and president under the Constitution of India. So this is the advisory opinion of the Supreme Court in this matter, right? So the next very important topic is infant deaths in a tribal dominated male guard region in the state of Maharashtra. So let's understand about the malnutrition problem, right? So other important aspects which specifically revolves around the issue of malnutrition. So for that particular purpose, this article has been given in the Hindu newspaper, and from the syllabus point of view, this is very important for the gender studies paper 2. So let's understand what is the context of it. So the context is that recently Bombay High Court has criticized Maharashtra state government and union government for extremely casual handling of the increasing malnutrition problem, right? So malnutrition related deaths of infants in Melghat. So Melghat is a tribal dominated region in Amravati district in the state of Maharashtra. So that means both central government and state governments have adopted a very casual approach when it comes to dealing with the problem of malnutrition-led infant deaths in this Melghat region. So most of the people are the tribal people who are affected by the malnutrition. Now, in fact, a petitioner informed the court that 65 infants who are in the 0 to 6 months of age had died due to the problem of malnutrition between June 2025 and till now. And over 220 children were currently classified as severe acute malnutrition. They have been suffering with severe acute malnutrition problem, and with half at risk of dying without immediate intervention. So this is what the petitioner has claimed before the Bombay High Court, that a lot of people have been suffering with the problem of malnutrition. So let's understand what exactly is malnutrition. Now, malnutrition is undernutrition or nutrition deficiency. It could be two different types. So undernutrition and overnutrition. So overnutrition may lead to the problem of overweight and obesity, but undernutrition or nutrition deficiency, it leads to the underweight. It leads to stunting of people, low height for age, and then wasting, low weight for height, right? So therefore, and it may also causes micronutrient deficiency as well. So I hope you have understood what exactly is the malnutrition and the problem in Malghat region of Maharashtra. So let's understand the Malghat's persistent malnutrition crisis and what is its current status. Right. So if you talk about this, Malghat region is a home to this Koruku tribal communities. Right. So it is home to the Koruku tribal communities, and they have struggled with a chronic infant and maternal deaths. However, most of these maternal and infant deaths in this Koruku tribal community of Malghat region can be associated with the problem of malnutrition and poor healthcare access that they have. However, government has launched several schemes for that particular purpose. For example, you have ICDS as an umbrella scheme, and you have ASHA workers, Anganwadi workers, ANMs, and you have National Nutrition Mission, Poshan scheme, PM Poshan Abhiyan, Poshan Pakwada. So number of schemes have been launched, right? So despite all these schemes and interventions, there is a persistently higher level of malnutrition because of the existing food insecurity, high infection rates, poor access to healthcare, and severe anemia. So these are the problems because of which the malnutrition is widespread in the Malghat region. Now, in fact, if you look at these infant deaths, so these infant deaths are very high in this Malghat region. So the reason being food insecurity, high infection rates of different diseases, poor access to healthcare, and severe anemia. Right. So in fact, this Malgam comprises Dharni and Chikaldara taluks, and it is having 324 villages. And in fact, the infant deaths in this area are persistently very high. So therefore, this is a cause of concern. However, so officials are arguing that the high infant mortality in this area is not solely because of malnutrition, but because of other reasons as well, such as anemia, sickle cell disease, pneumonia, and even delayed treatment due to poor connectivity as well. So these are the other reasons for the higher level of infant mortality in these areas. However, petitioner maintained that malnutrition further increases these issues, right? So illness, and therefore making them fatal without any timely care. Right. So let's understand what are the persistent challenges which are actually fueling malnutrition problem in the Malghat region. Right. Now, in fact, the one problem that Malghat region has been facing is the infrastructure deficit. No connectivity, no health care, so no awareness campaigns, right? So there is an infrastructure deficit which has been existing, and this infrastructure deficit leads to the urgent delay in providing immediate medical care. So this could be the one reason. And the second reason is poor connectivity. Now, when you have a poor connectivity, it is nearly impossible to reach a healthcare facility as quickly, as early as possible. So this also further increases the existing problem of infant deaths and maternal deaths. So this could be the second most important reason. And there is inadequate electricity supply, so that further affects the homes and healthcare facilities of the people. And then there is a huge shortage of the primary healthcare centers in these areas. And even if there are primary healthcare centers, there is absence of medical staff, absence of nurses, absence of doctors as well. So for healthcare, they need to visit hospitals which are far away from their location. This could be another major reason, right? So all these factors that we have just discussed, so these factors have been contributing to what? They have been contributing to increased or persistently higher levels of infant deaths as well as the maternal deaths, along with the problems of malnutrition and other illnesses. Now, in fact, there is a fragmented governance and poor coordination because there are different departments: education department, healthcare department, central government, state government, tribal ministries. So everything need to work in coordination. But there is a poor coordination to address this problem of malnutrition, and there is also a fragmented governance. As of now, most of these departments are working in silos, leading to irregular supply of nutrition supplements. And apart from that, weak monitoring of malnutrition cases, poor coordination in implementing policies. So this fragmentation has further undermines even well-designated interventions as well. Now, what solutions are needed to tackle this problem of malnutrition in the Malghat region? Right, so if we talk about the solutions to address the problem of malnutrition, now in fact, it actually requires interventions more than food distribution. For example, it demands a holistic, coordinated and systems-based approach, taking into consideration all the problems, all the stakeholders, all the departments. Right, so this is a coordinated and a holistic policy program is required to address the problem of malnutrition. And apart from that, the government needs to focus on creation of infrastructure. Now, infrastructure in the sense that there should be proper road connectivity, better health care. For that particular purpose, primary healthcare centers need to be established, and these primary healthcare centers must be having all necessary medical equipment along with the medical staff as well. And therefore, apart from that, there is a need for Anganwadi workers working in coordination, ASHA workers, ANMs. So they used to take care of nutrition, and at the same time vaccination and immunization of children in those areas, so that the children will not suffer from these diseases. The state governments may come up with specific programs providing nutrition food to these areas where there is a higher levels of malnutrition, right? So apart from that, so empower ASHA workers with strong training, Anganwadi workers, ANMs provide regular training, and apart from that, integrate health and nutrition interventions, right? So you have to integrate, provide primary health, establish primary health care centers to provide immediate medical care, and at the same time provide a nutrition as well, provide nutrition along with nutrition awareness. So this integration will be helpful. So all these measures have to be adopted to address the problem of malnutrition in the Malghat region, and also immediately stop the infant deaths and deaths of the the adolescent girls and other vulnerable people. Now, another very important topic is Justice Suryakant takes oath as a 53rd Chief Justice of India. Right, so therefore this has been given in the Hindu newspaper, and from the syllabus point of view, again this is important for general studies paper 2. So let's understand about this, how appointment is being made, oath ceremony details, the powers of the Chief Justice of India, everything can be understood, right? So in fact, who administers the oath of the Chief Justice of India? President Draupadi Murmu. So therefore, President administers the oath of Chief Justice of India. Now, the 53rd Chief Justice is Justice Suryakant. And apart from that, so this swearing in ceremony of every Chief Justice of India will take place in the Rashtrapati Bhavan because this is an established convention. Right. So in fact, Justice Suryakant's appointment as the next CJI was officially notified on October 30 in accordance with the collegium recommendation. So it's a system which is called as collegium system. So the collegium system deals with the appointment and transfer of judges. So collegium system recommend names to the president for the appointment as judges of the Supreme Court and High Courts, and accordingly president may take a decision on appointment of the judges to the higher judiciary. Right. So in fact, so he takes over the post from Justice B.R. Gavai. So he was the 52nd Chief Justice of India and who demitted office on completing his tenure recently. So let's understand the appointment of Chief Justice of India. So the appointment's constitutional basis is Article 124 Clause 2. Article 124 Clause 2. So President appoints the Chief Justice of India. Right. So in fact, the convention in India is the senior most Supreme Court judge is appointed as CJI based on the recommendations of the collegium system. So I have already told you what is a collegium system. Collegium system is a body, so where the judges are being appointed by the judges alone. And in fact, the tenure of the Chief Justice of India, so he serves until the age of 65 years. Right. So apart from that, his oath is administered by the President of India under the 3rd schedule of the Indian Constitution. Right. So under 3rd schedule of the Indian Constitution, the oath is being administered by the President of India. Now, what is the role of Chief Justice of India? Right. So Chief Justice of India heads the Supreme Court and collegium system. Chief Justice of India is also known as Master of the Roster because he allocates judicial work and the heads benches as well. And in fact, he also supervises functioning of the entire judiciary, and he plays key role in the appointments and transfer of judges in the collegium system, and he may interact with the UN special rapporteurs on the international legal matters as well. So this is the role that CJI performs in specific. So next one, Goa tiger habitat climbs, and from the syllabus point of view, this is important for general studies paper 2 and for prelims exam as well. This is very important. So based on this, I have a prelims based question. So let's try and answer this question in the comment section, and the correct answer will be provided to you in tomorrow along with the explanation. So consider the following statements about the National Tiger Conservation Authority. So it is a statutory body established under the Wildlife Protection Act 1972, and Prime Minister of India is the chairperson of National Tiger Conservation Authority. National Tiger Conservation Authority approves the tiger conservation plans prepared by states. So which of the statements given above are correct? So try to answer this question right in the comment section. So that's all for today, and thank you so much. So please subscribe our YouTube channel and also like the video. Thank you.